guys, welcome to the CLJ Judgement Series. This is the fourth episode where we shall be discussing about the case Shailendra Swarup versus the Deputy Director. Let's start with the basic facts of the case. The Modi Xerox Limited did not submit the exchange control copy of the custom bills of entry or postal wrappers as evidence of import of goods into India. The company provided for 4 transactions and chartered accountants certificates for balance of about 16 amounts which were untraceable. The company amalgamated and merged into Xerox Modi Corporation Limited. In the case of Shailendra Swarup versus the Deputy Director, the Enforcement Directorate, the Supreme Court bench comprising of Justice Ashok Bhushan and Justice R. Subhash Reddy, delivered a judgment stating that the proceedings complying with Section 68 of Foreign Exchange Regulation Act 1973 depends upon the nature of role one plays in the affairs of the company or an organization and not only upon the designation or status in the company. The Enforcement Director had filed a notice against all the directors, including Mr. Shailendra Swarup, who is a practicing advocate of the Supreme Court of the company, which goes by the name of Modi Xerox Limited. The appellant Shailendra Swarup argued against the notice of the Enforcement Directorate by stating that he was not associated completely with the company and he was only a part-time non-executive director of the Modi Xerox Limited. He was neither the employee of the company nor did he hold any executive position in the company. The Deputy Director, Enforcement Directorate, imposed a penalty of Rs 1 lakh on all the directors, including Mr. Shailendra Swarup. The order issued by the Enforcement Directorate was validated in the Appellate Tribunal and the High Court. The appellant then went to the Delhi High Court and it was then stated that as per Section 68 of FERA 1973, offences by companies as to every person who, at the time of the contravention was committed, was in charge of and was responsible to the company for the conduct of the business of the company as well as of the company shall be deemed to be guilty of the contravention. The legal fiction triggers on fulfillment of conditions as contained in the section. This provision cannot be read to mean that whosoever was a director of the company at the relevant time when contravention took place shall be deemed to be guilty of the contravention. The legislature intended that all the directors, irrespective of their roles and responsibilities, shall be deemed to be guilty of contravention. The section could have been worded in a different manner. This is purely a case where the liability has been fastened on the appellant without there being necessary basis for any such conclusion. The educating officer has enormously imposed penalty on the appellant for the alleged offence under Section 8, subsection 3, Section 8, subsection 4 and Section 68 of the FERA Act 1973. Next, coming to the question of law, the liability to be proceeded with for offence under Section 68 of the FERA 1973 depends on the role one plays in the affair of the company and not on mere designation or status. There were 3 issues which were raised in this case. Firstly, whether the plea taken by the appellant that he was only a part-time non-executive director and was not in charge nor even responsible for the conduct of business of the company at the relevant time was an afterthought. Secondly, whether the appellant has not brought any material on record either before the educating authority or the appellate tribunal to prove that he was only a part-time non-executive director not responsible for the conduct of the company at that time of the commission of the offence. Thirdly, whether the educating authority, appellate tribunal and the High Court holding the contravention of provision of Section 8 subsection 3, Section 8 subsection 4 and Section 68 of FERA Act 1973 by the appellant without there being any material that the appellant was responsible for the conduct of business of the company at the time of commission of the offence and without recording any specific findings to that effect. Coming to the judgment, this appeal deserves to be allowed to the judgments of the High Court as well as those of the educating officer and the appellate tribunal are set aside. The appeal is allowed and the penalty imposed on the appellant is set aside. While concluding, it can be drawn that from this judgment is that the liability to be proceeded with for offence under Section 68 of the FERA Act 1973 depends on the role one plays in the affairs of the company and not on just designation or status. Section 138 of the Negotiable Instrument Act with respect to offences by companies, a complaint in writing has to be filed as required by Section 142 of the Negotiable Instrument Act. The Supreme Court has held that for proceedings against a director of a company for contravention of provision of Foreign Exchange Regulation Act 1973, it should be necessary that at the time of offence was committed, the director is in charge and is responsible for the conduct of the company and for the business of the company. Drawing a correlation between Section 141 of the Negotiable Instrument Act 1981 and Section 68 of FERA 1973, the court explained that the Section 141 of the Negotiable Instrument Act contains the same conditions for a person to be proceeded with and punished for offence as contained in Section 68 of FERA 1973. While coming to the aforementioned conclusion, the court noticed that Section 141 subsection 1 of Negotiable Instrument Act uses the same expression, every person who at the time the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offence. It hence said that Section 68 of FERA 1973 as well as Section 141 of the Negotiable Instrument Act deals with the offence by the company in the same manner. The bench also had noticed that Section 68 of FERA 1973 deals with offences by company and Section 68 subsection 1 creates a legal fiction that is, shall be deemed to be guilty. The legal fiction triggers on fulfillment of conditions as contained in the section. The provision cannot be read to mean that whosoever was a director of a company at the relevant time when contravention took place shall be deemed to be guilty of the contravention. Had the legislature intended that all the directors, irrespective of their role and responsibilities, shall be deemed to be guilty of contravention, the section could have been worded in a different manner. When a person is proceeded for committing an offence and is to be punished, necessary ingredients of the offence as required by Section 68 should be present. The bench had agreed with the submission that FERA 1973 does not contemplate any complaint, but the scheme of the Act indicates that a person who is to be proceeded with has to be made aware of the necessary allegations which may constitute an offence on his part. There was a further explanation that in FERA 1973, for imposing a penalty under Section 50, the adjudicating officer is required to hold an inquiry after giving the person a reasonable opportunity for making a representation in the manner. Even though the FERA 1973 does not contemplate filing of a written complaint, but in proceeding as contemplated by Section 51, the person who has to be proceeded with has to be informed of the contravention for which penalty proceedings are initiated. Now, coming to some of the important precedents that had affected the judgment of this case, they are N.K. Wahi versus Shekhar Singh, National Small Industries Corporation Limited versus Harmeet Singh Paintal, Pooja Ravinder Devi Dasani versus the State of Maharashtra, N. Rangachari versus Bharat Sanchar Nigam, and lastly, which is the most important case that has affected this judgment, is SMS Pharmaceuticals Limited versus Neeta Bhalla. Even in the case of SMS Pharmaceuticals versus Neeta Bhalla, the law laid down by the court is that for making a director of a company liable for the offences committed by the company under Section 141 of the Negotiable Instrument Act, there must be specific averments against the director showing as to how and in what manner the director was responsible for the conduct of the business of the company. From the case of National Small Industry Corporation Limited versus Harmeet Singh Paintal, it was laid down that it is very clear from the above provision that what is required is that the person who are sought to be made vicariously liable for the criminal offence under Section 141 of the Negotiable Instrument Act, it should be at the time of the offence was committed was in charge of and responsible for the company for the conduct of the business of the company. Every person connected with the company shall not fall within the ambit of the provision. Only those persons who were in charge of and is responsible for the conduct of the business of the company at the time of commission of an offence will be held liable for the criminal action. It follows from the fact that if a director of a company who was not in charge and was not responsible for the conduct of the business of the company at the relevant time will not be liable for the criminal offence under the provision, the liability arises from being in charge of and responsible for the conduct of the business of the company at the relevant time when the offence was committed, and not on the basis of merely holding a designation or office in a company. Section 141 of the Negotiable Instrument Act is a penal provision creating vicarious liability and which, as per settled law, must be strictly construed. It is therefore not sufficient to make a bald cursory statement in a complaint that the director is in charge of and responsible for the company for the conduct of the business of the company without anything more than as a role of the director.